Hello and welcome to ESCA Legal Lounge. My name is Kimber Marie. I'm an IP associate here at ESCA, and I'm here today with our litigation partner, Leo Lichtman. Hi, Leo. How are you?
Hey, good. How are you?
Doing good. I have a few questions for you today. And so, just to get started, I figured we'd start off talking about what are some mistakes that you remember clients making that had a negative effect on their IP rights.
Sure. So I would say the biggest mistake, or I don't know if it's a mistake really, or really just bad practice, which is not registering your works with the Copyright Office. So registration of your works with the Copyright Office is important for a number of reasons. One is if you ever need to file a lawsuit, you're required to have a registration. And so if you're in a situation where somebody's infringed and uh, you, one, need to prove you're the owner, and two, want to be able to pursue a claim against them if necessary. If you don't already have a registration in place, you're going to have to register and then uh, either, unless you get an expedited registration for a couple $100s, uh, typically registrations can take a few months. So you're going to be sitting around waiting for a while if you don't already have a registration. The other thing is that registering early carries a really important benefit, which is if you register your work before the infringement commences, or if you register it within 3 months of when you first publish the work, you get the benefit of being able to elect what's called statutory damages. And statutory damages basically mean that you can uh, collect an amount somewhere between $750 or up to $30,000 per work infringed, or more if the infringement is willful. And actual damages, well, that's a consideration there. It doesn't need to be proven the way it would be if you actually had to prove actual damages, and that's really important because a lot of the time in copyright cases, actual damages can be tough to prove, frankly. And the other thing too is you get the ability to seek attorney's fees if you prevail in the lawsuit. And basically having the ability to, one, not have to necessarily prove actual damages with certainty, and also the ability to potentially collect attorney's fees if you win, it gives you significantly more leverage in a situation when your rights are infringed. And it makes it a lot harder for somebody else to really jerk you around. And so it's really just important to register early for those reasons. The other thing I'd mention is sometimes a lot of people know, and generally speaking, when you get into a dispute, you're told by your lawyer not to destroy or delete anything that could be relevant to the dispute. But it's important to know that sometimes you delete things unintentionally, and all too often there's situations that can come up where, for instance, your email service is automatically deleting things after a certain amount of time or something like that. And if you don't turn those things off after the dispute, those things that get deleted can potentially still lead to negative consequences if you're in a litigation. So, obviously it's important to listen to your attorney, um, and uh, and go with their advice. But that's just something that I think gets overlooked sometimes.
Yeah, those are great. I would imagine that a lot of people have not heard those before, so thank you for sharing them. Next, I had for you, what is a win that you've had that demonstrates why clients should care about their intellectual property registrations?
Sure. So one that comes to mind for me is a couple of years ago, I represented a music group that got sued for trademark infringement because they had a similar name to another music group. And the first music group that sued, uh, and they'd reached out years earlier claiming that our clients were infringing their rights. And while there was some communication back and forth, they ultimately went away and then never really resurfaced until our clients were getting ready to release their next album years later. And what happened after they sued, although our position was there wasn't any infringement to begin with, we were successful in getting the case dismissed without even turning to the infringement question on the grounds of what's called laches, which is it's a equitable doctrine that basically prohibits somebody from sitting on their rights for too long. If you delay unreasonably in bringing a lawsuit and it prejudices the other side, you can essentially lose just on that basis without even getting into the merits of your claim. So it was a great win for us. It was a victory. It was an important win. It was one of the few cases where we got a determination like that early in the case. But it's also a good lesson for the owner or the plaintiff in that action, which is that it's important to act on your IP rights, and trademark law in particular. You carry a duty to enforce your rights or you can lose them. That doesn't just come up in laches, it comes up in other situations too. For instance, there's something called genericide, where your trademark can eventually, if it's not enforced and other people use it in the same way, it has the risk of essentially becoming a generic term for whatever the product is you sell.
Awesome. And then my last question for you today, Leo, is what would be advice you'd give other lawyers, maybe new lawyers, about litigation that you wish you had heard earlier?
Sure. So that's a great question. I would say for younger lawyers, and this is something that it started to become apparent to me when I started to feel comfortable as a litigator, which didn't come right away, because one thing I realized is, especially now when I'm leaning on younger attorneys, is when you're first starting out, you're not expected to know everything. In fact, you're not even expected to know that much, frankly, because law school, while it teaches you a lot of things, it really doesn't teach you the ins and outs of private practice and the kinds of issues that arise on a daily basis. So it's important as a young attorney, one, don't be so hard on yourself. I know I was. If it feels like you're a deer in the headlights, sometimes that's okay. I know a lot of us who go to law school and go into litigation, especially, can be somewhat A-type and deal with imposter syndrome. But I just want to say, as when you're a newer lawyer, it's perfectly okay when you're starting out not to know that much. Instead, I would say that the key things that make a newer lawyer, especially a really junior lawyer, really valuable and highly regarded at a firm and working on a team is, one, your attitude, having an open attitude, the ability to learn from mistakes, the ability to really listen to direction and take it. And if there's any constructive criticism, really taking it to heart and learning from those things. And then two is really taking the initiative to be able to think through problems and think through the questions you might have before you bring them to maybe a supervisor's attention, for instance. Not knowing the answer to something, it's perfectly fine when you're a newer attorney. You're not going to have the answers. I mean, even as you get more senior, you realize you don't always have the answers. But there's a big difference between a junior lawyer who comes to a partner with a question and they say something like, here's the problem, now what do I do? Versus a junior attorney who comes to a partner and they say something like, here's the problem, I think this would be the solution, but I would appreciate your thoughts. If I'm wrong, tell me. And that latter approach is just so valuable, not just because it adds value for the junior who is taking the time to think through something and provide a framework to the more senior attorney, but it also helps that junior develop an important skill early on, which is that ability to develop instinct from seeing a situation, thinking through how it might play out if you go one way versus the other, and really kind of coming to a solution in your own way. And even if it's the wrong solution, that thought process of uh, what do I do? Okay, here's how I think I want to tackle this problem. It just, I think, helps you really develop. And of course, the key when you're junior is, not just shooting the trigger. It's of course talking to other people on the team and talking with senior attorneys, but having the initiative to think through the problem first yourself uh, is such an important skill that I think junior lawyers should develop early on.
Amazing. That's great, Leo. So, just to recap for our listeners, it sounds like your advice for the clients is that you want to act on your IP early, especially with copyright registrations, and you want to make sure that you are enforcing those rights. And then for lawyers, especially young lawyers, your advice was to be open minded and take ownership over your work and go to the partner with questions and solutions, not just problems. So, thank you for that great advice, and thank you for your time, Leo.